Hello and welcome to this update about the replacement of the Child Contact Assessment with the Child Contact Screening. I am the Adult Standards and Community Notification Coordinator to the Colorado Sex Offender Management Board, and my name is Michelle Gang. The changes we are going to discuss are significant. The revisions highlighted here are available online in their entirety in Section 5.700 of the Adult Standards and Guidelines for the assessment, evaluation, and behavioral monitoring of adult sex offenders. In light of case law, the standards and guidelines now allow for contact with an offender's own children when the court or parole board has not prohibited such contact. If the court or parole board remains silent, the contact must occur. Probation conditions allow for contact unless the child is a victim of the convicted sex offender, and in many circumstances, parole also allows contact. The original purpose of the Child Contact Assessment is no longer relevant within this context, and contact is being ordered without the assessment being completed. The assessment is being used differently in that courts are frequently ordering it as an informative tool while contact is occurring, whereas previously the CCA was relied on for recommendations regarding contact with one's own child prior to the contact occurring. The CCA duplicated many of the required areas of the sex offense-specific evaluation, and the CCA was often cost prohibitive for most clients. Given the above information and the recommendations of the 2014 external evaluation, the board approved the replacement of the Child Contact Assessment with a more streamlined Child Contact Screen. It is important to note that unlike the Child Contact Assessment, the Child Contact Screen is not an assessment tool. It is not scored, and it does not provide a risk level for a convicted sex offender's contact with their own child. The Child Contact Screen identifies research-supported risk factors to be screened as part of a consideration for own child contact. In making such decisions, all clinical indicators should be considered. Standard 5.730 is the introduction to the Child Contact Screening and identifies when a child contact screening can be initiated. This section continues to require that a client desires to have contact with their own children and requests such contact occur. Simultaneously, they cannot meet any of the exclusionary criteria as established in Section 5.725 of the Standards and Guidelines. They cannot have two or more pre-screen factors as listed in Section 5.734, and the client must not have a history of victimizing any of their own minor children, regardless of the victim's age, as substantiated by criminal or civil court history or by self-report. This section now also includes that the client not meet the additional disqualifiers as listed in Standard 5.733. The disqualifying factors have always been in existence, but not immediately referenced in this section. A significant change is that Level 3 denial has been eliminated as a pre-screen factor. The research is not conclusive on denial as a risk factor for recidivism, and as such has been removed as a potential factor in preventing a client from having contact with their own child. The required areas of screening are found in Standard 5.735. Many of the required areas of the Child Contact Assessment duplicated the tools and processes required to be completed in the sex offense-specific evaluation. These duplications have been eliminated. The remaining required areas concentrate on parenting involvement and skills, as well as family stability issues not addressed within the sex offense-specific evaluation. For example, the client's attachment style and ability to place their child's needs above their own remains a required factor to screen. Sexual risk remains a required factor to screen, and that information can be pulled from the sex offense-specific evaluation. There is no requirement or expectation to do a second sexual interest or sexual arousal assessment. One significant requirement has been added. An evaluator completing the child contact screening must contact the custodial parent or legal guardian and ascertain whether there is support for the contact between the client and their own children. The support or lack of support must be included in the final report. Given the changes, the child contact screening must be completed in conjunction with or upon the completion of the sex offense-specific evaluation and should be included as an addendum to the SOSE. Additionally, any approved evaluator may complete the child contact screening. There is no additional training required, and the handbook has been eliminated. As I mentioned earlier, the entire section on the child contact screening has been added to the electronic standards and guidelines on our website. I encourage you to read that entire section prior to conducting a child contact screening. If you have additional questions about the child contact screening, please email or give me a call. I really do appreciate your hard work and dedication and always enjoy hearing from you. Thank you, and please remember to take care of yourself.